Welcome to the 10th installment of the Divorce Law Monitors webinar series. And today we're going to be talking about relocating with your children outside of Massachusetts during divorce. Please know that we pre-recorded this webinar, so we will not be able to take live questions. However, we will put our email addresses up at the end. So if you have any questions, please feel free to reach out to me or Francine Gardines, who is participating in this webinar today as well. So let me introduce myself. My name is Robin Lynch Nardoni. I am the chair of the Divorce and Family Law Group at Burns & Levinson. I focus my practice on divorce and child custody matters, including relocation. I have been at Burns & Levinson for more than 20 years and all that time practicing in divorce and family law. So let me turn it over to Francine to introduce herself.
Thank you, Robin. I am Francine Gardines, and I'm a partner here at Burns & Levinson as well. I have been here for almost 17 years. I too practice exclusively in the divorce world and also focus on custody matters, and have just recently tried a removal case. And happy to have you here with us and look forward to hearing from you at the end of this presentation.
Okay, so first up, this is Massachusetts General Law, Chapter 208, Section 30, which is our statute dealing with relocating, which is called removal. Okay, so if you want to relocate with your children outside of the Commonwealth of Massachusetts during or after a divorce, this is the statute which would apply to that removal. As you can see, it says a minor child of divorced parents who is a native or who has resided 5 years within the Commonwealth and over whose custody and maintenance the probate and family court has jurisdiction shall not, if of suitable age to signify his consent, be removed out of this Commonwealth without such consent, or if under that age without the consent of both parents, unless the court upon cause shown otherwise orders. The court upon application of any person in behalf of the child may require security and issue writs and processes to effect the purpose of this and the two preceding sections. This statute prohibits removing of the child without consent. And if without consent of the other parent, the court has to order that the child can be removed upon cause shown. You'll see also here in the statute that the statute talks about the child's consent. So we are going to delve into, sort of break apart this statute, look at the pieces of it, and look at what our case law says relative to removing children from the Commonwealth of Massachusetts.
As Robin mentioned, we are going to break down the statute piece by piece. And the first section is purpose. The purpose of the statute, of course, is to allow the custodial parent to remove or relocate with the children. However, the purpose also is to ensure that the rights of the non-custodial parent, or the parent who remains in Massachusetts, would have the ability to maintain and develop and continue his or her relationship with the child. So it's definitely a balancing act and a balancing test that the court needs to apply. Not only the real advantage that a custodial parent needs to prove, but also the best interest of the child, which necessarily coincides with his or her relationship with the mom or dad who is remaining in the state.
Okay, thank you, Francine. The first words of the statute, General Law, Chapter 208, Section 30, are that a minor child of divorced parents, that is the beginning of the statute. Even though it talks about divorced parents, this statute also applies to non-marital children, meaning children born to parents who are not married to one another. And that is because of our statute, General Law, Chapter 209C, Section 1, which says that non-marital children have the same rights and protections under the law as children born to parents who are married. Because of that, the case law has interpreted that this statute, despite it saying it applies to children of divorced parents, also applies to children who were not born of parents who are married. Additionally, though, the case of Smith versus Mcdonald, which is on this slide, is a case in which the child was born outside of marriage. The father was not on the child's birth certificate. The mother moved out of Massachusetts prior to the father establishing his legal rights as a parent of that child. The father filed a paternity action in court after the mother had moved out of Massachusetts, and the court ordered the mother to bring the child back to Massachusetts. That was overturned on appeal because permission to relocate out of Massachusetts is not required when a child has only one legal parent. And when paternity or parentage has not been established for the second parent, that first parent has the right to move out of state with the child. So looking at the statute, a minor child of divorced parents, keep in mind that it also applies if the parents were never married to one another.
And one thing, Robin, I think we should add is that if there is a father who has not established his parenting rights, it's the first step that he must take in order to activate, if you will, the removal statute.
Correct.
The next section of the statute talks about a child who is native of the Commonwealth or has resided 5 years in the Commonwealth. One of the cases that dealt with the birth of a child and the parentage of a child and whether or not the child was actually a native of the Commonwealth was Miller versus Miller. In this case, the court found that the removal statute did not, by its terms, apply to the party's daughter who was born in Uganda to a US citizen father and a mom who was a German citizen. And technically the child, the little girl, was not a native of the Commonwealth because she had not been born in Massachusetts, and nor did she live in Massachusetts for 5 years. However, and this is really quite interesting, that the court still applied the removal statute and all of its terms, even though the child did not meet the criteria of a native or residing in the Commonwealth. In fact, I have not, or nor do I know of any cases that have really contested the validity of whether or not a child is a native or has resided in the Commonwealth. Therefore, so even if a child is under the age of 5 or was not born in Massachusetts and has lived here for less than 5 years, the courts have typically applied all of the removal statute and case law to determine whether a child should be removed from Massachusetts.
Okay, so now within the statute, it talks about that a child shall not be removed if of suitable age to consent without that child's consent. There is actually no case law interpreting what is that suitable age for consent. Under our guardianship laws in Massachusetts, the age of 14, a child over the age of 14 has to give their consent to a guardianship. That does not exist in this removal statute, and there is no case law that says what that particular age might be. Same with a divorce case. You know, in a divorce case, the child of a particular age doesn't get to say they want to live with a particular parent. So while the statute does say that the child's consent is required, there is no case law that says a child of a certain age can make that determination. Even if, say, you have a 16-year-old, that child consenting to the removal does not guarantee that removal is going to be allowed. The court will consider the child's preferences depending on the child's age and level of maturity. I will say, though, that courts routinely do not want children to testify in a custody dispute between the parents and not in a removal action either. Instead, the courts typically hear from the children either through an attorney appointed for the child. This is a program where attorneys, Francine is one of these attorneys that volunteer through the court system to act as counsel for the child. The attorney for the child appears as an attorney in the case and represents the child's position with the child as their client. The other option is what's called a guardian ad litem investigation. This is where the court appoints either an attorney or a mental health professional to do an investigation. Part of that investigation is that the guardian ad litem will typically typically, depending upon the age, again, speak to the child and hear what are the child's preferences with regard to removal and custody, and report that to the court. The guardian ad litem does an investigation that speaks with the parents, and as well as other collateral witnesses that the parent might present to the guardian ad litem, such as a grandparent, a coach, a teacher, someone who's been involved with the child who could provide information that's relevant to this investigation. And then oftentimes the court will ask the guardian ad litem for an opinion on whether or not removal should be permitted. Is it in the best interest of this child to be removed? Other judges will just ask for the guardian ad litem to gather the information, but not provide an opinion on the removal, but rather what would be the parenting plan if I let this parent remove the child? What would be the parenting plan if the child stays? So I think, Francine, do you have anything to add relative to age of consent?
I will. Thank you,
okay.
Robin. There's two items. One, with regards to the attorney representing children, it's called the ARC program. And while that is not a guaranteed option, there are many judges who do appreciate having an attorney who can be the voice of children. And it's typically children who are of age whose voice would count. For example, it would not be, a 4-year-old's choice, but perhaps a 14-year-old or a 16-year-old. And also, while judges don't like to have children testify, I actually did try a removal case probably about 10 years ago, where there was a judge who did allow the oldest of 3 boys, who was about 16 years old, to testify and to provide his feedback with regards to whether or not he wanted to leave Massachusetts and live with father in New York City. It was certainly an unusual event. It actually has never happened in my 20-year career, but for that one time. But the judge at that time thought it was best to hear from the oldest child. So that was actually quite interesting. Also, with regards to trying to determine whether or not a child is of age where a judge will listen to him or her, we often joke that if a child can make decisions by deciding with his feet, so to speak, which means that if he can go from one house to another on his own, a judge would start listening or perhaps give credence to a child's desires and wishes in terms of who he may want to or who she may want to reside with. The next part of the statute talks about whether or not a parent who wants to remove can have show good cause for the removal. So upon cause shown is the statutory basis for excusing the other parent's consent to remove the child. So what does upon good cause shown? That there are a number of factors that a court will look at, anything from new job, new spouse, moving back to where a parent originally hailed from, or a number of those factors combined with together. This perhaps is probably the hardest part of a removal case, which is what is enough to show to the court to be able to remove the child. Will one factor be enough? Do you need a multitude of many factors, including a new job, or returning to a home, or having the support of family members? I find that judges struggle the most with this, and attorneys do as well, in terms of what is enough to actually prove that a removal is warranted. Of course, you have to always balance that with the best interest of the child. Robin, is anything you want to add on that?
Well, I will add this case, Pizzino versus Miller, as well as multiple other cases, actually say, as it's quoted here, that upon cause shown means only that it's in the best interest of the children. But as Francine just went through some factors, we're going to look at those. There are multiple other factors that actually the court will consider. And despite the fact that the cases repeatedly say it only means best interest of the children, that's not really the case, because we have case law that has interpreted this to tell us that there are many more factors that we need to look at. So the first step in determining whether removal will be allowed is to look at custody. If the parent seeking removal has primary custody of the children, then the real advantage test applies, and this is found in the Giannis case. If the parents share physical custody, then the court will use a best interest of the child analysis, which is articulated in the Mason versus Coleman case. In determining whether the parties share physical custody or one has primary physical custody, the court is going to look at what is actually happening in the situation and not the labels that are contained within the parties' separation agreement or judgment of divorce. Because sometimes parents are not following the parenting plan that is articulated in their agreement. For example, it might say we have shared physical custody, but then the plan is actually not a shared plan and one parent has significantly more time. Or they have a plan that calls for a 50-50 sharing, but what they've been doing over the time is not that plan, and it is distinct from what is written in their agreement. So the court is going to look to the actual parenting that is occurring before determining automatically it's shared because their agreement says so, or it's primary to one parent. So that is the first step, because before you can take the next step and look at what test to apply, you need to know first, is it shared physical or is it primary to one parent?
And I think, Robin, what's so important is if there is an agreement that talks about primary, but there is the development of the relationship with the child and the parent, or even the two parents who really become co-parents, the court will look at the fact that that second parent or that other co-parent who may not have on paper had primary custody also has participated in a quite meaningful and perhaps even equal or more than equal share of the parenting. So if a parent really truly has primary physical custody, what is applied is the real advantage test. This is a test that has been developed through case law from many, many years ago. The original case is the Giannis case, which was decades old, and it talks about whether or not there is a real advantage for the primary custodial parent to move. So the two-part test, the real advantage test, is applied when considering the custodial parent's proposed removal of the minor child out of state, whether there is good reason for the move or a real advantage, which requires that the custodial parent must show a good, sincere reason for wanting to remove to another jurisdiction. The trial court must also consider the reasoning, the soundness of the reasoning for moving, and the presence or absence of a ulterior motive or a motive to deprive the non-custodial parent of reasonable visitation. There are many situations we have, which is unfortunate, but there are times when removal is motivated by the desire to limit and or somehow disadvantage the other parent by taking the child from him or her. If the court does not find a real advantage, then the test and the case ends and removal is not allowed. However, if the court does find a real advantage and that the custodial parent has the ability to move and her or his interests and reasoning are sincere, then the next step is whether or not that move is really in the best interests of the child or children.
So let's look at best interests of the children and what's involved in determining whether that test is met. So we put here on the screen the factors that the court will consider in looking at the best interests of the child. The first is whether the quality of the child's life will be improved, including improvements that flow from the improvement in the quality of life of the custodial parent. So what this means is that essentially a happy parent may be a better parent. So if the custodial parent's life will be improved by that move, whether it's through a change of job, moving to be with a spouse, going back to family of origin, if that provides a quality of life for that person that will make them happier, it's sort of the trickle down theory that that happiness will flow down to the child because the parent will be better able to parent. So the court is going to look at that to see how the quality of the child's life will be improved by that move. The court is also going to look at any adverse effect related to the disruption in the relationship with the custodial parent. We're going to look at that relationship separately as we move forward with this. So we'll get into some more of those things. The third is the extent to which moving or not moving will affect the child's emotional, physical, and essentially psychological development as well. So this is going to look at school systems. What is the difference between the school systems here, the school systems where the party is seeking to move? What activities are available? Are they seeking to remove to some remote location where the child isn't going to be able to continue to participate in activities? Or are they looking to move somewhere where there is a great school system, more activities available? This also would look into their social development. What about the friendships that they have here? What will they be leaving behind? What have they established here? So how is this going to impact the child? This is also important relative to any child with special needs. If it is an autistic child, a child with physical needs that need to be met through the school system or through programs outside of the school, are those things available to this child in the new location? Those are important to how the child's needs can be met by moving or not moving. 4 is the interests of both parents. Francine's going to look at that in our next slide, so I'll hold off on that one. As well as they're going to look at the possibility of an alternative visitation schedule. Now, visitation is not a word that we use at this point. We're talking about parenting. What is the parenting time going to be for the parent who's not moving? This is important to look at. What does the travel look like? You know, a parent removing to Connecticut or Rhode Island or New Hampshire is not going to impair the relationship with the other parent as much as perhaps someone who's moving to California or Idaho or somewhere where there's airline travel involved. So the court's going to look at, what is the travel for this child? Do we have a 2-year-old who's going to be expected to take airline travel and 2 hours of car ride to get from the house to the airport? Are we talking about a 16-year-old who can make that airline trip alone? So the court will consider how the parent staying in Massachusetts is going to be able to continue to see this child and the impact of that on the child in the travel itself. None of these factors necessarily weighs more than the other. The court will look at all of them, but the court can balance them in the way that the court sees fit. So the court may put more weight on the factor of quality of the child's life and be less concerned about the possible alternative parenting schedule for the parent left behind. It is up to the court to weigh these factors appropriately. Also, again, this is where the GAL investigation could come in. If you are the parent seeking to remove, you want to provide the guardian ad litem with all of the information about how the child's life will be improved, how moving will positively impact the child's emotional, physical, and developmental needs, and propose an alternative parenting schedule for the non-custodial parent. If you are the parent who doesn't want the child to remove, you want to show how all of these things are positive here in the child's life in Massachusetts and how those things will be impaired by the move. These are things that can be provided to the guardian ad litem and help the guardian ad litem provide this information then to the court in weighing these factors.
So one of the things that we need to consider after the real advantage and whether or not the custodial parent has proven that, it's whether or not it's in the best interest of the child to move. But that also another factor which comes into play is whether or not the non-custodial parent will ultimately lose, you know, a significant, meaningful relationship with the child or children. You know, obviously, if there is a major change in terms of where the child is going to live, just, you know, practical facts apply that their relationship is going to change. They're not going to be able to just pop in and have time on, you know, a Wednesday and go see the baseball game or the ballet recital. So the non-custodial parent's life and time with the child will definitely change. The question is whether or not the disadvantage is so significant that would prevent a move. So as Robin mentioned, one of the things that needs to be taken into consideration is travel and where the new home would be for the child. If you have a situation where the parent lives in the northern part of Massachusetts and the other parent wants to move to New Hampshire, well, it's not so hard to imagine that you can certainly be meaningfully participate in the child's life by going over the border, a 10 or 20 or even a half an hour car ride. It's much different, however, if there's airline travel or, anything that would add perhaps an hour of time and really does create a disadvantage and wrinkles the relationship between the non-custodial parent and the child. Also, the court really must look at details and facts of how involved the non-custodial parent is. This is where it's so important, if there is a GAL involved, to really detail all the things that a non-custodial parent has been involved in, whether it be coaching a team or participating in the the PTO, or having meaningful religious experiences, anything that really has shown or can show the court how important and how involved a non-custodial parent is in the child's life.
And I would just add to this, Francine, that where a non-custodial parent has been somewhat uninvolved, that may make it easier for the court to make a decision that the other parent could remove the child, given that there may be a parenting plan that says this parent is going to see every other weekend and Wednesday overnight, but if they're not exercising that or canceling it all the time, that type of thing, doesn't go to parent-teacher conferences, doesn't participate in any way. If they then come to the table when the parent is seeking to remove the child, the court and the guardian ad litem are going to kind of look back at that history and say, hey, you haven't been involved. Maybe your decision to come get involved now isn't going to hold up enough to stop this other parent from removing.
Right, and I think that's so important, that the label is not what makes the court's decision. It is the actual relationship, and the facts are particular to the involvement of that parent.
So we have looked at so far what is the test if one parent has primary physical custody, but there's a different test if the parties share joint physical custody of the child. Where the parties are sharing physical custody, the best interest it's a different test. It really involves looking at the best interest of the child as the primary factor relative to whether a child can be removed. The judge's willingness to elevate one parent's interest in relocating is diminished. So that real advantage to that parent who might be moving back to family or a new job doesn't weigh in this test where they have joint physical custody. The real advantage test is not applied in this instance. Instead, it's truly just the best interests of the children. Yes, the court is still going to look at, is there a sincere reason for a move? So if, again, as Francine talked about earlier, if the parent seeking to move is shown to be wanting to make that move basically to interrupt the relationship with the children, that's going to weigh against that person, even if there might be other factors to show it could be in the best interest of the children. That is still going to be a factor. But otherwise, we are looking at what is in the best interest of the children, and all those factors that we looked at earlier relative to best interests are going to be the main test here, where the parties have joint physical custody. And where I wouldn't say it's impossible to remove where the parties have joint physical custody, but it is a somewhat more difficult analysis and decision for the court to make, basically because, as you see here, the parties are jointly scheduling everything for their children, participating actively jointly, and so they've given up somewhat by agreeing to be joint physical custodians of their parents. They've given up their right to certain life decisions, and one of those is the choice of where they might live. So it's a little bit more difficult where the parties share physical custody. Again, not impossible, but just a little bit more difficult where the parties are sharing physical custody of the children, for one parent to seek a removal that's going to significantly impact the relationship with the other parent.
And Robin, just so everyone is clear, you know, the court cannot prevent an adult from leaving the state. And so one's right to travel and to leave the state is still preserved. It's just a question of whether or not you leave with or without a child or the children of the relationship. So one of the things that the court needs to first establish is really what type of custodial arrangement there is. So the court, during a divorce, if someone is in the middle of a divorce and not a modification action and not where there's already been an established custody, the court must take into consideration and first must establish whether or not there is going to be a shared custody arrangement or a primary physical custody to one parent. So it's not a fait accompli if there is a temporary order where one parent has more parenting time than the other, that automatically that parent will be able to remove because he or she has primary custody. For example, you know, cases often start off in, some cases start off in, you know, in a really contested manner where the court will, after a brief motion hearing, order a temporary order case where, for example, mom has primary custodial parenting, yet dad will accept it at the time, but there's going to be a trial on custody and dad is seeking 50-50 custody. So the court cannot base its decision of removal on that temporary order. The court must listen to and take in all evidence and decide first that what the custodial arrangement should be for that child after a full divorce hearing, and then can apply the removal standard. So we have had recent cases where there's this misunderstanding or belief that a temporary order will determine what the court can or will do in a removal case, and that's simply not the case. The judge must listen to all the evidence, first decide a custodial arrangement, and then apply whether that is the real advantage standard or the best interest of the child standard.
Okay, so there are situations where a non-custodial parent has already moved out of Massachusetts and then comes back and seeks custody of the children, which would then, of course, require a removal so that the child can come live with that parent out of Massachusetts. In this instance, as you can see here, the non-custodial parent's initial move out of state must be shown to have not been done for the purpose of interfering with the in-state person's parent's relationship with the child and wasn't designed to establish a basis to request the removal. For example, the person can't move out of state for the purpose of then coming back and saying, now I want to remove the child. They have to have had that sincere reason for the move. It is similar to the real advantage test in Giannis, where that parent must show that they are rooted in the community that they've lived in. So they're not just moving there for the purpose of saying, now I want to bring the child and get them away from the other parent. They have to have established a life in that new community where they have moved to. The court can consider in determining whether they're rooted in the community, their employment, their financial situation, marital and emotional situations, their housing. And then again, they have to make the determination that it is in the best interest of the child for, number one, for the custody to change from the custodial parent to the non-custodial parent. And then two, that it is in the best interest of the child for that child to move with that, what was non-custodial parent out of the state. And essentially now the non-custodial parent becomes the custodial parent. This was a recent case you see cited here of last year where one of the parents had already moved, I believe, to New Hampshire and was looking to have the children come based on kind of some problems that were occurring in the household with the parent that was living in Massachusetts. So it's unusual, but it does happen where, you know, one person has already moved and they need to completely change the custody arrangements, and it can happen under similar to that Giannis test.
So what about the concept of in-state removal? What does that mean? Typically, that means that you have parents who are in one part of the state originally. For example, they are living in Pittsfield, Massachusetts, and then the parties divorce, and father wants to move to the Cape, which from Pittsfield down to the Cape could be a 2, 3, maybe even a 4-hour drive in the summer. The court, what does the court do in that situation? Technically, it's not a removal out of state. What the court does look at, though, again, is the factors that we've discussed. Is that a real advantage for that father to have moved to the Cape? Does it impact the ability for the child to maintain a relationship with the mother? Or does the travel to and from Pittsfield to the Cape cause a disruption in the child's life? Is it truly in the best interest of the child to travel that much? This in-state removal actually happens more often than not, given the distances between one corner of the state to another. There are often, this in-state removal concept is also applied when there is a parent who wants to remove, for example, in the state to one of the islands, whether that be the Vineyard or Nantucket. So the court, although it's not a removal from the state, will still apply the removal standards. And again, the court will apply the removal standard, which applies to the custodial arrangement. Is the custodial arrangement a primary custodial arrangement? And then the real advantage test must first apply. Or is it a joint custodial arrangement where the Mason case would apply and the best interests of the children really need to be considered?
And I'll just add to that, Francine, I think a lot of times it occurs after parents are divorced, the custodial arrangement is set, and one of them just up and moves, not understanding that essentially they needed to get permission of the court if they were going to move to a place that would involve a significant disruption to the non-custodial parents' time with the children. So we often then get involved in cases where the move has already occurred, and now one is saying you didn't follow the requirements of this statute and the case law, that you needed to get the court's permission in order to do this. And it can get messy when we're trying to undo what's been done because people didn't understand that they needed to get the court's permission.
So at the beginning of this webinar, we started talking about all the things that a court could consider with regards to removing, and whether or not a custodial parent could take a child or children out of state. Just to highlight the factors that are certainly considered by the court, whether or not a new spouse is living out of state and there's an imminent marriage or a marriage has occurred. Oftentimes a parent's right to remarry is not limited in any way, but what a parent doesn't realize that once they remarry and they want to move out, it doesn't necessarily mean that the court is automatically going to allow a removal. So a marriage.
Let me just interrupt. I just want to say that the new marriage, a marriage to a spouse who's living on a state, is per se a real advantage. So you don't then have to meet the real advantage test. But as Francine was going to say before I rudely interrupted, you still have to meet the best interest of your child standard. So I just wanted to jump in and say that Giannis does tell us that a new marriage is per se a real advantage. Go ahead.
Thank you, but that's okay. So with Giannis, there's 2 steps, as Robin pointed out. So moving out of state, you've met the first, marrying a spouse and moving out of state, you have met the first prong, but then there's the second prong.
On the change of job. So there's often a case where a party has obtained a new career, a new job that takes them out of state, and they want to take the children with them. This can provide certainly a real advantage to someone if, one, there's been a loss of job here in Massachusetts and an inability to find something, or that there's such a significant increase in income that this can change the lifestyle for the parent and the child. So again, a job change is a positive reason to move and will likely help show that there's a real advantage to this person, again, you still need to meet the best interest of the child.
So another factor is whether or not the parent would like to, move back home to their original home state. And that is, again, one way to show a real advantage, which is, returning back to their mom and dad or siblings who can provide them support. And that really is in conjunction with the next point, which is when you're returning home to your state and you have the ability to rely upon parents or siblings or relatives to provide and join in care of the child, that is something that a court will also look at. But I think in conjunction with the change in job, or in conjunction with another factor that's been proven that would benefit not only the parent who wants to remove, but also would trickle down to the child.
And that goes into the next point, which is lack of a support system here in Massachusetts. So again, there are cases where people are permitted to remove children out of the country to go back to their family of origin. And part of the consideration is that that person is here. Maybe they came here for a job originally, or they came for college and met someone and had a child, and they have no support system here in Massachusetts. They don't have friendships. They don't have family here. They don't have someone to give them backup childcare. And so that lack of support system here will weigh into the party's ability to remove from Massachusetts because there's something else somewhere. But additionally to the something else somewhere, nothing here that helps them live their lives, go to work, and support their kids because they don't have a support system here.
So we've mentioned this before, but the trying to escape or get away from the other parent is not a be all and end all. And the court actually will only look at that, not only I should say, but the court will certainly weigh that if there is a situation where there is domestic violence or abuse. But the court must also weigh, again, the best interest of the child and whether or not there's going to be a support of the relationship between that other parent who's remaining and the child, and to ensure that that child's relationship is not something that is destroyed or in any way taken away from the child. And not only the parent, remember, the court is always looking at what a child's needs are and balancing the child's relationship with the non-custodial parent and the custodial parent.
So then we have health reasons. So there may be, the child may suffer from an illness and the hospital in Chicago has the best treatment for this child and the child needs to live near there. That may be a reason to support a move. A parent may have health reasons similar to that, needing to be near a particular facility to receive proper treatment. Or sometimes people make the claim, for example, that living in Arizona provides a dry climate, which will help with certain illnesses and make them feel more healthy, which will then trickle down to the children being happier because the parent is healthier and more able to parent. These things need to be actual and they need to be sincere, not things that are, I don't like the cold and therefore I want to live in a climate that's warmer because, my feet won't hurt because it feels more comfortable. They have to be valid health reasons, and know that if a parent is raising a health reason for wanting to move either for themselves or the children, the other side is going to dig into those health reasons, and medical records are going to come into play in the case to look at whether these are actual health conditions that need to be improved by a move versus, something that this person is sort of making up for the benefit of, well, here's something I can claim. Well, then they're going to go look at your medical records, and there better be some health treatment in there where doctors are telling you that this move is in your best interest or in the best interest of the child, because without that, those health reasons are likely not going to suffice if they're just sort of add-ons or sort of made up things to try to add to your reasons for wanting to move.
And so the final point, of course, is just for a change. In my opinion, a court will not allow this to be the only factor for removal. it would certainly not be in the child's best interest that one parent just wants to up and leave because they need a change of scenery or a change of pace. It's truly something that a parent has to show that moving out of state would really benefit them, provide them with a new support or a stronger support system, and provide a better financial picture for the child. So the court will look at any number of these factors. As Robin had said earlier, they don't weigh one in particular, but remember, this is just one step in the custodial parent's attempt to remove. The court always will put the child's best interest first in primary.
So that basically concludes what we have to say about removal. We have our email addresses up here. If anyone has any questions, please feel free to reach out or call us and let us know if we can answer any questions for you. We'd be happy to do that and take the time to chat about any issues that you that were raised for you in our presentation.
Thank you for joining us today.
Thank you.